tutorial later, which will be answering some questions. A CPR criminal procedure, which tomorrow on Saturday you guys have to be writing. So without wasting any time, let's go to the business of the day and start. Okay, let's start here. In 1988, Eddie Crook and two accomplices, Adam Schindler and Petty Thief, allegedly committed the crime of theft and corruption in the Republic of Zamunda, where they were visitors. Eddie is subsequently arrested by the police of the Republic of South Africa, and then Eddie was 72 years old when he was arrested. Then question number 1 is asking, in terms of the basic jurisdictional principle of South African law, South African courts only enjoy jurisdiction and respect of offences committed on South African soil. Based on the fact above, provide a critical discussion on whether a South African court can have a jurisdiction over Eddie in these circumstances. Before I answer this question, you must remember what happened to, who is that guy? The pastor Bushiri. Bushiri committed a fraud in South Africa and corruption. Then he escaped the country to Malawi, which is his country. Then in Malawi, he has not been arrested. However, South African applied for extradition to extradite Bushiri to South Africa. So I'm just giving you some of the things about Pastor Bushiri that is going on, right? And then when we talk about the age of the guy who's 72 years old, before we even talk about it, we can just give example by Jacob Zuma. What happened to Jacob Zuma, right? Jacob Zuma was over 72 when he went to jail. So I'm just giving you some overview, some things that are happening in general out there that you can actually apply in the law. So now let's go and try to find the answer. Firstly, when you answer, you have to state very clear that the general principle is that the courts of the Republic will exercise jurisdiction with regard to offences committed on South African territory only. Then you go and stated the exceptions. Those are the exceptions apply regarding the following offences. Someone who has committed a higher treason or treason, by its very nature, higher treason is an offence which is frequently committed on foreign territory, e.g., where South African citizen in a wartime happens to be a resident in an enemy country and joins the enemy army in order to overthrow the South African government. The crime of the genocide, the crimes against humanity and war crimes, those that are falling under the Roman Statute. If you know the Roman Statute of the International Criminal Courts, they are there. And then trafficking of a person, a South African court will have a jurisdiction to hear a charge of a theft committed in a foreign state, not because it is regarded as a theft in the foreign country, but because an accused is regarded as continuing to appropriate the stolen object with the necessary intention in South Africa. So it means that if you committed a theft in another country, you will be charged in South Africa. Offences committed on ships, offences committed on an aircraft, offence committed on the territory which is annexed by the Republic. So let's go back to the question. The question made it clear that the guy called Eddie has committed a theft, and according to South African law, the theft of, if you committed a theft from other country, they can able to hear such a case. Therefore, AD will likely to be, the case of AD will be heard in South African jurisdiction. Let's go to another question. The law enforcement authorities of the Republic of Zamunda want to extradite Eddie to their country to stand trial on the charges. The Republics South Africa and Zamunda have a formal extradition treaty. However, the death penalty is a recognized form of punishment in Zamunda if an accused is convicted of a theft from the people. Explain whether the government should, in the context of South African jurisprudence, extradite Eddie to Zamunda. Then you must come and answer by telling them that where a person commits a crime in one state and flees to another state and then fails to return of his or her own accord in an endeavor to escape the consequences of his or her act, the state where the crime was committed is powerless to act. Extradition makes provision for such a person to be extradited to the state in whose area of jurisdiction the crime was committed in this manner. States are obliged to extradite criminals. An obligation to extradite can only come into being in terms of agreement, which is a treaty. A state may, however, if deems it proper because of mutual ties of friendship, for example, extradite a criminal to a foreign state on that state request. Nevertheless, a state will not easily extradite its own citizens except in terms of an agreement. Such an agreement can be contained in the treaties, what we call the extradition treaties, which can be granted in respect of serious crimes. A person may not be extradited if it is about the crime of political in nature. Then there is those terms of the treaty you must know. However, the most important thing is to focus on the case of Minister of Home Affairs versus 7. This is a very good case which you must use. If they said that in Minister of Home Affairs and others versus 7 and others 2012, the Constitutional Court was tasked with deciding the extradition fate of two Botswana nationals who were facing separate charges of murder in their homeland. In both instances, the Botswana authority had refused to provide guarantees that the accused will not be sentenced to death as soon as they delivered to Botswana authorities. AFI mean the President establishing Mohammed versus the President of South Africa. The court upheld the constitutional protections contained in Section 10, 11, and 12, and to which the defendants were entitled. The court maintained in this regard the notion that South African Constitution does not recognize exceptions to the protection of the right to life, the right to human dignity, and the right not to be treated or punished in cruel, inhuman, or degrading way. According to the court, therefore, the South African government has no power to extradite or deport in any way, remove from South Africa to a requesting state an extraditee if the knowledge exists that the accused will, if deported or extradited, face the real risk of the death penalty being imposed and executed against him or her. The real risk of the danger of the imposition of the death penalty is established when South African government seeks and fails to obtain a definite guarantee from the requesting state that the death penalty will not be imposed upon conviction. Where South African authorities know that delivery of the extraditee to the requesting state could lead to the imposition and execution of death penalty upon conviction, the act of extradition essentially facilitates the imposition of the death penalty and is in breach of the state obligation contained under Section 7 of the Constitution. The court held in addition that the accused could not be extradited in spite of a long-standing extradition agreement, as extradition would essentially violate Section 10, 11, 12 of the Constitution. It is worth noting that the extraditee in Mohammed suffered the unfortunate fate of extradition to a state which had not made a safety guarantee in respect of the death penalty. but whose laws nonetheless sanctioned its imposition. Sadly, the court judgment in this regard was only delivered after the applicant had already been extradited. A person who extradition is requested has to sort before a magistrate court, blah, 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 blah. Then we have answered the question. Therefore, it doesn't matter whether Samunda treaty, according to the treaty, the person must be extradited. However, South Africa will not extradite a person who is going to face a death penalty. Therefore, the AD will never and will not be extradited to Zamunda. Let's go to another question. Don't forget that case of a minister. It's a very crucial case in examination. Now let's go to number 3. In terms of the Section 18 of the Criminal Procedure Act, the right to prosecute by the state lapsed after a period of 20 years from the time when the offense was originally committed. Explain whether AD or any of his accomplices may be prosecuted in South African court on the alleged offenses. So we are basing on the Section 18, which says that they lapse after the period of 20 years. So let's read this Section 18 together so that we answer the question. Section 18 says that the right to institute a prosecution for an offense, this is a prosecutor who must do those. They said that the right other than the offenses of a murder, treason, robbery, kidnapping, child stealing, rape or compelled rape, the crime of genocide, trafficking in persons for sexual purposes by a person, using a child or a person who is mentally disabled for pornographic purposes. And then they say that shall, unless some other period is expressly provided by law, lapse after the expiration of a period of 20 years from the time when offense was committed. So this one that I mentioned here will never lapse, whether the period is over 20 years or 60 years. If you have charged with murder, you always be charged with murder. We have seen by Kobe. What do you call Kobe? In America, they are still instituting the rape cases. R. Kelly is another person, for example, that the rape was. South Africa, we have a Jup who is going through the rape case. Yeah, it's going. When we go back to this question, we can state that the AD, since AD has just committed a theft and corruption, AD offenses will lapse after 20 years because it doesn't fall under those exceptions. So let's go to number 4. AD subsequently makes representations to the Director of Public Prosecutions, arguing that the prosecutor should exercise his discretion and not to prosecute him by taking into account AD's personal circumstances, critically evaluate AD's submission to the Director of Public Prosecution. So this is AD. The AD doesn't want the Director of Public Prosecutions to prosecute him, maybe because of his healthy or yes, he's healthy maybe, or his any personal circumstances. So what happened if the person now is facing the personal circumstances and doesn't want he wants the prosecutor to exercise the discretion? Then you must come here to 4.1.14, the discretion to prosecute, where South African compulsory to prosecute where there's a prima facie case. Then sometimes at there reasonable prospect of success. The prosecution, it has been held, it does not have to ascertain whether there is a defense, but whether there is a reasonable and probable cause for prosecution. Then there was a case. The prosecution must at the trial be able to furnish proof beyond a reasonable doubt. Occasionally, there might be a good grounds for refusing to prosecute despite the fact that prima facie case exists. Such grounds may be the triviality of the offense, the advanced age or very young age of an accused, where a plea bargain was struck between the prosecution and the defense, or the tragic personal circumstances of an accused. For example, a father who has, through his negligent driving, caused the death of his young children. Then the former DPP described discretion as a very valuable safeguard because one has to take into account what the consequences too may be apart from the penalty which court law might inflict. If in our view the consequences are all out of all proportions to the gravity of the offense committed, we are permitted to exercise our discretion and decline to prosecute. So this was another DPP comment, which is a very good comment. Then we rely on this guy's statement that a valuable safeguard where the consequences too or maybe apart from any penalty which court law might inflict, if in our view the consequences are out of all proportions to the gravity of the offense committed, we are permitted to exercise our discretion. So let's go to another question. We have stated those things that the court will, the prosecution first will likely to see. Those are the age, the personal circumstances, and then we supplement with what the DPP was said. So let's go to number 5. The charges of a fraud and theft are subsequently put to Eddie in the subsequent trial upon which he pleads not guilty. Briefly explain in light of the above whether the case may at this stage be withdrawn by state. If so, why? And if not, why not? Then the charge of a fraud and theft are subsequently put to Eddie in a trial, and he pleaded not guilty. And we are explaining whether at this stage a case may be withdrawn by the state or not. If not, why? And number Roman figure 2, briefly explain in light of the above whether the prosecution against AD may be stopped at this stage. If so, why? And if not, why not? So we are explaining two things. We are explaining whether his case may be withdrawn after pleading not guilty, or it can be stopped after pleading not guilty. So we are going to explain all of them. Then here the court has made the distinction between withdrawal of charge and stopping of the prosecution. All right. The prosecuting authority may withdraw a charge before the accused has pleaded to such charge. However, the accused is in this circumstance not entitled to a verdict of acquittal. He or she may be prosecuted again on the same or related charges. For example, where new evidence is discovered, a prosecutor may withdraw a charge without the consent of his or her DPP. The reason for this is that a DPP, if dissatisfied with the prosecutor's withdrawal of the charge, may charge the accused afresh. Before an accused pleads, the prosecution can also withdraw a summons and issue another. A DPP may at any time after an accused has pleaded, but before conviction, stop the prosecution in respect of that charge. If this is done, the accused is entitled to be acquittal. This means that in any subsequent prosecution in respect of the same fact, the accused can successfully rely on plea of previous acquittal. So we have already know by now that after pleading, the case may be stopped at any time by the prosecution, and we have seen the reasons. And then withdrawal, we have so known that it takes place before the accused pleads. Then after pleading, it's all about the court. It's all about the prosecutor to exercise the stopping or not. So let's go to number 6. The investigating officer, Inspector Nosike Kanas, has in the meantime received anonymous information alleging that some of the loot from crime committed by Eddie and his accomplices is still stashed in Eddie's house. So the investigating officer, Inspector Nosike Kana, in the meantime received anonymous information alleging that some of the loot that he looted is still stashed in Eddie's house. Discuss whether Inspector Kekana may enter Eddie's house for the purpose of interrogation without a warrant. So the question is asking whether the person can be searched without a warrant, right? So let's also discuss the question in the Roman figure 2, which says that discuss the general principle applicable in respect of a search warrant, and also whether Inspector Kekana may search Eddies without a warrant. So number 1, we are talking about the interrogation without a warrant. Number 2, we are talking about the searching. So let's start with let's answer all these Roman figure 1 and 2. So let's start with Roman figure 2. We have a search in terms of search warrant, which is based on section 21 and 25 and 2 of the CPR, which you must go and read them. Subject to the provision of section 22, 24, and 25, object can only be seized in terms of section 20 on the authority of search warrant safeguard. Then we have requirements here, which of the search warrant, which are there. The warrant must be issued by magistrate or judicial officer. Then we have also search without a warrant here, which is based on section 22 and 25 also. Section 22 authorizes the police officers to act without a warrant in 2 situations: if the person consent to the search and seizure of the article concerned, or if the person who can consent to the search of the container or premises consents to such a search and seizure of the article in question. If the police official on a reasonable grounds believes that a search warrant in accordance with section 21 will be issued to him if he applies for a search warrant and delay in obtaining such a warrant. Then section 25 subsection 3 made it clear that a police official may act without a warrant if he believes on a reasonable grounds that a warrant in terms of section 25 will be issued to him if he applies for such a warrant, and that the delay in obtaining such a warrant will be defeat the object thereof. Whether reasonable grounds existed is objective question. Roman figure 1 will just say that section 26 and 27 made it clear that although the police may question any person regarding an offense that they are investigating, it occasionally happens that the person whom they wish to question is on private premises, and the person in charge of the premises refuse to allow the police to enter the premises in order to question him or her. This may effectively prevent the police from asking the persons any question, and thus from obtaining from him or her any information that he or she may have. To solve this problem, section 26 and 27 has it. In terms of section 26, police official may, in the investigation of an offense or allegedly offense where he or she reasonably suspects that a person who may furnish information with regard to any such offenses on any premises, enter such premises without a warrant for the purpose of interrogating such person and obtaining a statement from him or her. There is, however, the provision that a police official may not enter any private dwelling without the consent of the occupier thereof. The reason of the provision is to prevent the police from violating, of course, private rights. In terms of 27, a police official who may lawfully enter any premises under section 26 may use such a force as may be reasonably necessary to overcome any resistance against such an entry, including the breaking of any door or window of such premises. In terms of provision, then blah 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 blah. Then we have answered the question. Now let's go to question number 7. The information relayed from Zamunda to the South African authorities that Eddie is a dangerous criminal who should be apprehended with the utmost circumspection, care and planning, as he is known to carry heavy artillery. The police sent a large contingent to Eddie's house to effect arrest. Upon seeing the police through the window, Eddie, who is in rush, forgets his walking cane inside the house, makes a sprinted attempt to escape through the back door. Captain Trigger Happy orders him to stop, but Eddie ignores the instruction and runs in the opposite direction. Trigger Happy fires 2 warning shots in the air and once more instructs Eddie to stop. Eddie refused to heed the instruction. Trigger Happy thereupon fires a shot hitting Eddie on the left leg. Critical evaluate whether a Trigger Happy's actions comply with the requirements for the use of force when effecting arrest in the context of section 49(2) of the Criminal Procedure Act. So we have already talked much about section 49(2), which talks about the force of arrest. So we won't be repeating this one. If you want to see, check my videos, other videos of criminal procedure. You will see that we have already dealt with this question. So let's go to another question. After the arrest warrant officer, truth seeker tries to interrogate Eddie, who bluntly refused to answer any question. Briefly discuss these rights and duties of truth seeker Eddie respectively in this regard. So we have already dealt with the question of a right to remain silent and all those stuff. We have dealt with it. If you do not know, go and check other of my videos of the CPR, then you will know. Let's go to number 9. In terms of section 50 of the criminal procedure, an arrest person shall be brought before a lower court as soon as reasonable possible, but not later than 48 hours after the arrest. Due to the injury sustained during the arrest, Eddie is only made to appear in court only 2 weeks after the arrest. Discuss the lawfulness of otherwise of bringing Eddie to court after the expiry of 48 hours. This you may check that the video that we have done. We have already done with this question, and I told you that the person, if it's not appearing in court in 48 hours, such a person must appear. The prosecutor will write a letter, the letter to the court to show that the person is in hospital, and the medication will be, the medical certificate will be attached to that application so that they can see and they state which court he is, or which hospital he is, and when is he likely to be brought to the court. So we have dealt with this one of 48 hours. Well, let's go to question number 10. Section 37 of the Criminal Procedure Act 51 of 1997 empowers a police official to take fingerprint samples from an arrested person. Eddie refuses upon request by warrant officer, truth seeker, to allow him to extract fingerprint samples from him on the grounds that the taking of his fingerprints is calculated to intrude on his personal integrity, result in cruel or degrading punishment, disadvantage him in future because the records of fingerprints remains on the system for a long. Evaluate ED objections against established legal principles. I'll try to answer this question, but we have already answered this question many times. It deals with from the Constitution that everyone has the right to personal integrity. However, when we deal with such cases, let's just answer for the sake of answering, but I've already dealt with in other CPR videos. Firstly, you must know that it must be appreciated that criminal procedure rules, although identifiable as an adjective law, do not and may not and cannot operate in isolation from common law and constitutional rights such as the right to life, human dignity, and privacy and bodily integrity, and extra. You must know what they are saying. They are not saying that it should never be against those rights. Remember, rights can be justifiable in terms of what? In terms of Section 36 of the Constitution. That's the second thing that you must know. Secondly, you must know the mandate of the police. In terms of Section 205 of the Constitution, one of the objects of the South African Police Service is to investigate crime. It sometimes happens that a crime is committed in the presence or not in the presence of the police. But once they become aware, they have to investigate. And the investigate will consist of asking personal questions in order to obtain information relating to the commission. If the police becomes aware of the commission of an offense when someone reports to them, they will rely on that person to furnish them with information concerning exactly what happened. The police will accordingly also ask such a person questions, and in the light of his or her answer, decide how to proceed with the investigation. So the main thing that I wanted you to show is that the police has a right in terms of 205 to investigate, which include questioning and to obtain the information. As a result of that, they need for special powers in order for police to do their works, in order to investigate. That's why they have said here that a person who is aware that someone has committed a higher treason or plans to do so, and who fails to furnish this information to the authorities, will himself or herself be guilty of higher treason. So there is some statutory that was enforced in order for police to do their job, because it's priority. So as a result of that, it's very much important to get into the examination knowing the powers with regard the powers that are conferred to police officers in terms of how they can interrogate a person at his house. Number two, how the police can obtain the name of address if the person refused. Detention of people for the purposes of interrogation, and how such interrogation will be taken, it will be effected. Powers relating to possible witness, how the witness may be obtained to be in the court. The powers relating to suspects and accused, how accused is going to be handled. Interception and monitoring, how the possible of interception and monitoring, because this violates the person's rights, such as listening to someone's conversation. The interception of post and private conversation between persons constitute a serious infringement of the privacy of individuals. Strictly measured were according laid down to maintain the confidentiality. Since the aforementioned measure, they protect the confidentiality of communication sent by post or may hamper the investigation of crime. Express provision was made for certain exceptions. According to law, enforcement officer may intercept communications in order to prevent serious bodily harm or to determine, in case of emergency, the location of some person at a given time. So they have such a right, police officers, to intercept and listen to what you are saying with whoever you are saying with. It's another powers that they are given, which are there. So I want to state the certain a bodily feature of a person is there on the book. The reason why the powers in respect of the body, prints, and bodily appearance of a person. This is regarding to the finger, palm, and foot printing. The samples is there as under section 37. I'm showing this one. If you get any question regarding the powers of the police, you may go to under the powers of the police. Then you read from under the powers of the police, so that you know everything about it. So in the examination, you can see that chapter 8 talks about those things all. So you go to chapter 8, then you finish all. So let's go to another question. All those things are there on the chapter 8. Let's go to 11. Captain Trigger Happy entertains peculiar notions about bail. He is of the view that either himself or the prosecutor should have the authority to adjudicate upon Eddie's bail application. Evaluate this ascension critical. Roman figure 2. Trigger Happy also insists that Eddie should not be released on bail on the grounds that he must be punished for his commission of the offense. Discuss Trigger's Happy statement in the context of bail and some of the fundamental principles of criminal justice. Well, we will just discuss this in a summary way, because I know that you know about this thing of a bail, right? You must know about the cancellation of a bail, that they check whether the accused may invade justice or not, can interfere with the witnesses, can defeat another justice. So they check those things when you want to be released on bail or not. You know those things. If you are doing law, or you have been in court, or you have been living in South Africa, you will be knowing this thing because it's happening each and every day. It's general. Then you must also read release on warning in terms of section 72. Apart from the above mentioned methods of obtaining the presence of the accused at the trial, it is also possible to release an accused on warning in terms of section 72 if an accused is in custody in respect of an offense and can be released by police official or court on bail in terms of section 59. So the police can release the person on warning, or the court can release the person on bail in terms of section 59 or 60. The police official or court can, instead of granting bail, release the accused in the case of certain offenses and warn him to appear on a specified date and time. Then you read everything and the requirements there. Then you finish to answer such a question. So when you answer these two questions, firstly you will check who must be released on bail, the conditions that they check when they release person on bail. Number two, you must also give that one of a warning, that they may issue the warning based on some certain offenses which are there. Then let's go to number 12. Eddie regards himself as somewhat of a legal fundi. Owing to previous numerous arrests, he is therefore aware of the principle that the burden of proof in criminal proceedings always rests with the state to prove its case beyond reasonable doubt. In the meantime, the court has ruled that the alleged offense against Eddie are to be classified for the purpose of bail proceedings under Schedule 5 of the Criminal Procedure Act. When the bail proceedings final commence in court, Eddie, who is not legally presented and insists on representing himself, raised objection when he realized that the onus of proof in fact rests with him as the accused. Critically analyzed whether Eddie's objection on regard the question of onus in bail application in context of the charges preferred against ED. Firstly, you must know that the onus in bail applications, as stated earlier, depends on the schedule under which the offenses with which the accused is charged. Right? It's based on the schedule. So that guy falls on schedule what? Schedule 5. Then it was further stated that the court's duty in a bail application was investigative and or inquisitorial, or whether the state will commence with the leading of evidence, right? And you must not know that it was held that there should not be any onus in a bail applications, which was decided in this case. And then when we go downwards, it was like in 1995, section 60 reintroduced an onus of an accused in certain circumstances, namely when he or she was either charged with Schedule 5 offense or when he or she was charged with having committed a Schedule 1 offense whilst on bail for a Schedule 1 offense, right? And then they said, while we are on honors, there is a clear distinction on who bears the honors in the so-called Schedule 1 and 7 offenses and that of Schedule 5 and 6. As we stated here before in the first category of offenses, the honors lies with the prosecution who has to start leading evidence. But in a later category, it is for the defense to commence leading evidence. It is therefore imperative to establish before the time what one is dealing with. That will determine whether or not Section 60 will be applicable or not. If you are representing the applicant in the bail application, it may be worth your while to insist on charge sheet fully completed by the state. Sorry. Then they said that it has now been introduced to assist the state in proving that the accused will be charged with Schedule 5 or 6 offense. In terms of this provision, the DPP's written confirmation that the accused will be charged with Schedule 5 or 6 offense when handed to court is prima facie proof that of that fact, and that accused will obviously then have to testify first. So it has now been amended. If it is a Schedule 5, it's a Schedule 5, then that guy must first to take the oath. It can't be objective because it's now clear. Lastly, guys, this criminal court manual book is the best book that you may have. I can assure you, with this manual book, everything will be easier. You can even see the way the content is written, that to find things here is very much easier. I've been using this one and I've written the examination using this book. This one is the best book. Well, everything here is it's easy to find. It's so simplified and easy to find. So using this book, I can assure you, it will be the best day in the examination. This book is well summarized in a way that understanding anything it's good and it's written well. So I can tell you that you must get Criminal Court Practice 2019. This book is a very good book, one of the best book. This Criminal Court Manual is the best book. Compared to this one, compared to this Juta, Tony, this book can make you fail itself the way it is. However, that other book can make you pass. And today we have an amazing offer, guys. We are giving for free meeting the team. Make sure that you have a team. Let me just say Microsoft team. Ensure that you have a Microsoft team which will join the meeting for free. This meeting will be taking place for free. You pay nothing, right? Today on Friday, 17 May 2024 at 7:30 p.m. we are starting the free meeting to all who wants to be bringing questions to the about the CPR where you do not understand. So bring any question you want. It's a free meeting today for everyone on our YouTube channel. It's a very good day. Bring any question you want about the CPR, right? We will meet at 7:30. And if you want to add it to the meeting, please write your name and send it to this WhatsApp number 061-984-2135. Then you bring any question you want at 7:30 for free. This is the offer for today, which is available for all our YouTube subscribers and those that are not subscribers. Okay, guys, make sure that you utilize this good opportunity. We'll see you at 7:30 today.